Family court operates under a severe math problem. Judges face an endless docket of high-stakes personal conflicts and strict time limits to resolve them. To survive that kind of overwhelming volume, professionals are forced to rely on heuristics. They use mental shortcuts and pattern recognition to process cases quickly, categorizing complex human behavior into familiar buckets, like instability, coercion, or noncompliance. This cycle is the echo. A courtroom tactic yields a short-term advantage. Opposing parties copy it. Professionals expect it, becoming standard operating procedure. System drift begins the moment a judge inadvertently rewards a manipulative shortcut because it fits an expected pattern. What gets rewarded gets repeated. By relying heavily on quick patterns to clear the docket, the legal system accidentally incentivizes litigants to use destructive tactics against the families the court is meant to protect. Litigants and their attorneys adapt to this environment by developing an adversarial playbook designed to exploit the court's reliance on mental shortcuts. One highly effective strategy is provocation as proof. A parent intentionally violates boundaries or baits their ex-partner to trigger a natural stress response, and then presents that resulting anger to the court as evidence of parental unfitness. Look at this timeline representation of context stripping. The instigator strips away the context of their own behavior, deleting the provocation entirely. They submit only the isolated reaction to manufacture a symptom of instability. The missing context is then replaced with weaponized labels. Instead of proving specific harmful conduct, the instigator applies clinical buzzwords like narcissist or borderline to paint the other parent as inherently dangerous. These labels bypass the judge's objective reasoning and trigger confirmation bias. Once the court accepts a label, it unconsciously fills in the blanks, interpreting neutral boundaries or minor mistakes as further proof of a deep pathology. Parties also deploy exhaustion strategies. They flood the docket with emergency motions, serial complaints, and endless discovery requests. They bleed the opposing party's finances and stamina, making the procedural process itself the punishment. These tactics do not uncover the truth of a family dynamic. They succeed because they hand the overloaded court a neat pre-packaged storyline that is easier to process than a complex, messy reality. Court evaluators face a difficult interpretive challenge that often leads to a major epistemological error. They routinely mistake visible distress for an active safety risk. High-stakes hearings trigger fight or flight responses. A parent crying, shaking, or rambling from sheer exhaustion is often diagnosed by the court as unstable. Meanwhile, a manipulative litigant delivering a polished, emotionless performance is read as credible and safe. The courtroom systematically misreads the raw data of human emotion. It penalizes victims for their very natural reactions to trauma, while handing victories to abusers who maintain their composure. The damage generated by these tactics eventually spills out of the courtroom and infects the surrounding community ecosystem. The family dynamic itself is corrupted through child leverage. Kids are drafted into the adult conflict, forced to act as messengers or subtly coached to generate evidence, leaving them trapped in intense loyalty binds. Parents then begin outsourcing their conflict, dragging teachers, school counselors, and local police directly into their custody disputes. The strategy here is to manipulate community professionals into generating official incident reports and documentation that can be used as leverage in the next hearing. Overwhelmed by a constant influx of manufactured drama, schools and mental health clinics develop severe litigation fatigue. To protect their staff from hostile cross-examinations and subpoenas, these institutions pull back. They refuse to engage, and families who have legitimate, urgent needs suddenly lose their community support networks. The courtroom echo teaches the entire community a destructive lesson. Escalation and manipulation yield better results than cooperation, leaving the broader society fractured and less resilient. Breaking this cycle requires a mechanical shift in how the court weighs evidence. The underlying incentives of the system must be re-engineered. This equation illustrates the first guardrail: behavior over labels. A judge strikes the clinical label, instead demanding specific data, action, date, child impact, and verifiable proof. The court also mandates context integrity bracketing that proof within a full timeline of complete, unedited communication threads. Evaluators train to recognize trauma responses. The court caps repetitive filings and shields children from adult interviews. When courts draw a hard line against procedural abuse and strictly enforce relevance, the echo changes direction. Litigants abandon toxic tactics and copy healthier, cooperative behaviors because the system